Common lease loopholes owners need to avoid. If you are a property manager or owner about to write a lease, you should consider some aspects of leasing. Usually, a property lease includes the major points and terms of the agreement. Certain actions by the tenant or the landlord can cause the lease to break. Meaning that if a tenant is negligent, damages the property, or doesn't pay rent, you as a landlord have a right to evict them. On the other hand, the tenant preserves a right to move out and end the contract if the landlord fails to provide suitable conditions for living by leaving the property poorly maintained. The lease should clearly state the terms and conditions of both sides. However, most times, there are instances where a lease lacks accountability for a condition or an exception. These occurrences are called lease loopholes. Let's take a look at the 5 most common and avoidable. Number 1. Maintenance guideline problems. The lease between a tenant and a landlord should clearly state which parts of maintenance must be dealt with by the landlord or the tenant. Although the law assigns certain responsibilities to one of the parties in some states, misunderstandings often occur and many issues are left out. You must make sure that any future disputes about which party should handle retained maintenance issues can be avoided. Maintenance issues that were caused due to lack of inspections or rose naturally over time are yours to handle. It's best if these terms are cleared up, negotiated, agreed upon, and included in the lease. Number 2. Rent price changes. This is another term that is mostly dealt with by the law in some states. However, not everything is made clear by legal systems. As a landlord, you don't want to be losing profit by accepting rent that was set before the prices of bills, groceries, and taxes were raised. When inflation occurs and you still have the same rent price set as you had in the beginning, you might be losing more money than earning. Therefore, it's best to include the right of a landlord to change the rent price if deemed necessary in the lease agreement. Your property manager at Triumph will help you set the terms in a manner that will be acceptable to the tenants as well. See description. Number 3. Issues in the neighborhood. Many property managers claim it would be beneficial to note in your lease that if there are issues due to the neighbor's behaviors, such as loud noises, the lease shall not be voided. The landlord should make sure that the lease includes a paragraph where it's clear that the property owner should not be held accountable for such problems. Number 4. Oral agreements. Frequently, landlords and tenants choose to make an oral agreement. If one of the parties breaks any of the terms they agreed upon, the oral lease might not be able to hold as much power as a written one. If you make promises to the tenant that you intend to keep, it's better to write it down and sign it. The same goes for instances where a tenant gives you their word to act on a certain issue. Number 5. Failing to mention names and numbers. A lease is an agreement between 2 or more adults on a property. Therefore, it's best to include names and numbers to avoid any big misunderstandings that could lead to court. Failing to write names and numbers in the lease allows the parties to be negligent with the terms. Arguing that their name was never mentioned could get them out of trouble and give you additional problems to deal with. To conclude, avoiding the common loopholes will help you avoid common problems that cause disputes between tenants and landlords. The important thing to remember when owning a rental property is that tenant satisfaction matters the most in this business.